With us, joining via phone, we had talked a little bit about the Supreme Court decisions. We have lawyer extraordinaire Jeff O'Brien. Jeff, how you doing?
I'm good. Good to be with you guys.
Good to have you here, too. So let's dive into it. These Supreme Court decisions, if you could first and foremost, we talked a little bit about the injunction one. You got two non-lawyers in here talking about it. If we could actually talk about I think it was 2 or 3 cases that were decided this week and their implications, Jeff. We'd love to hear from you about them.
Yeah, you start with the insurance case or the other one?
I would say let's start with the injunctions case, because I know that there's more to it, specifically in that, it wasn't about injunctions. Like, I think there's some strategy there behind the Trump administration. Initially, it was about birthright citizenship, but they kind of used this interesting kind of, backdoor to try and kind of kill the universal injunction. So if you could just kind of give us like your analysis and take on that. And if your cell phone is kind of spotty, we'll let you know.
Sounds good. Yeah, AK, that's a good. This originally was the case on birthright citizenship, and it sort of morphed into this decision on the universal injunctions. It was an application for partial stay. So it's not. We all knew. I think that it wasn't going to be a decision on the merits of birthright citizenship. That one is coming at a later date, but. So what was before the court was this issue that we've all been talking about, is these district court judges, these federal district court judges issuing injunctions that are not just applicable to the parties in the case. Because that's typically, the cases that I deal with, you go for an injunction, you're dealing with that particular case. You're not talking about something that applies to everyone. And it's happened on both sides. There was this Corporate Transparency Act that was out there last year, and there were courts issuing injunctions nationwide on that. But more recently, it's been these cases, curtailing the administration's agenda. And I listened to you guys talk about the Justice Coney Barrett, which I have one of those notorious ACB shirts, and I think she finally earned the shirt.
Love it. Yeah, no, it was brutal, man. I love that takedown.
But I think there was more to it than taking down Justice Jackson. I think that really what she was going after, trying to get to, was the dissent. Justice Jackson's dissent is really dangerous in its reasoning. This idea that if you don't like what the executive's doing, if the courts think it's unlawful, then they have the ability to just overrule the executive branch. That's not how our Constitution works. And I think that's what lit the match with Justice Coney Barrett, was more about this. If you read that dissent, the part that they're all talking, or her opinion about the dissent, the part that everybody's reading, you could also read that was her telegraphing to the district court judges, knock it off.
Yeah.
You don't have the right to do this. So I think there was more to it. She used everybody's talking about some of the stuff, Justice and some of the kind of unusual lines of thought in her dissent, and the way she went after him. But I don't think that Justice Jackson was necessarily the target. That was Justice Coney Barrett was going after the line of thinking in the courts that lead to these results.
Jeff, do you think, I think AK mentioned before, and I'm not sure what the exact number was, but you also had other judges sign on to this dissent. Do you kind of get the sense that there's, a lack of, AK talked about it before, like a lack of respect for Ketanji Brown Jackson? Is she proving as a justice to be that incompetent at her job?
I don't know that you can read this as a lack of respect. Like I said, I think this was very much directed at the thinking in her opinion, and Justice Coney Barrett believing just how dangerous that thinking is to our judicial system.
Well, let me ask you this, Jeff. AK Kamara here. I don't think you and I have ever chatted before, so nice to meet you. I've heard your analysis throughout the last few years that I've been on the show. So mad respect. I like a lot of the way that you're able to break things down. Can you kind of give us a more concise breakdown of what was the main crux of the argument in regards to Jackson's defense of using these universal injunctions against the administration, and then also Amy Coney Barrett's kind of rebuttal of that. Can you kind of give us maybe a clearer analysis on that?
Yeah, so AK, Justice Jackson, her opinion, the crux of it is that at the end of the day, the courts are the last word, right? Like it's that they have the check over what she called an imperial executive, which is not how it works. When Justice Coney Barrett cites Marbury v. Madison, one of the earliest cases that is really about separation of powers, what the majority opinion says is even there are instances where the courts may find an action to be unlawful, but you can't in turn then take an unlawful action to curtail that unlawful action. You have limitations. Like I said before, an injunction can apply to the parties in the case, but this is not something that one person can go up and you ask for an injunction across the entire country. So that's what it's really the focus here is. The Jackson dissent is really unmoored from anything having to do with the Constitution. If the judge doesn't like what the executive's doing, they have the ability to. And Barrett just said that's really dangerous, and that's not how it works.
Switching lanes here, Jeff, because we did have a number of cases that got decided this week. There was also this case impacting Medicaid funding for abortion. Can you tell us a little bit about that one and what maybe the impacts? I'm specifically interested in what the impacts in Minnesota could be, if any, on that case.
Yeah. So there's a case that's called Medina v. Planned Parenthood. This is about the state of South Carolina prohibiting Medicaid funds from going to Planned Parenthood. The federal government sends Medicaid funds back to the states for various health care services. And, the state of South Carolina decided that Planned Parenthood was not going to be the recipient of these funds. And so Planned Parenthood sued. And the court came down and said that, no, the states have the right to block the Medicaid funds from Planned Parenthood. In terms of its application here in Minnesota, certainly, if the make of the state was different, it's something Minnesota would have the ability to do. But we also have the Doe v. Gomez case, which enshrined abortion right in the state constitution. So you'd have to, in order for this to really do anything here, you'd have to have basically, take over pretty much everything and the Supreme Court, which that's not going to happen for a long time. So it really doesn't, practically speaking, it really doesn't have an impact in Minnesota just because the makeup of things and the way that the dominoes are set up here. That's just not going to happen. As long as that Supreme Court case is the law of the state, it isn't happening.
So that's fascinating. Everyone has their own, we'll call it ox to gore in this case. Whenever you hear about this case, you'll see people here in Minnesota politically that are like, see, this is why Republicans need to grow a backbone and now we need to make the move to defund Planned Parenthood through our Medicaid. But what you're explaining is that if you look at the specific, it's because South Carolina legislatively made these moves, and then obviously Planned Parenthood or Medina ended up suing, saying like, you can't do this, blah, 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 blah. And so ultimately what you're saying is that because of the specifics of how our state is set up, we wouldn't be able to make this move just straight up because of the precedent of Minnesota State Supreme Court Doe v. Gomez, between the age outs that exist on the current Supreme Court makeup. You would have to have Republicans controlling probably the governor and, at least maybe the state house, if not both house chambers. And you would have to have that long enough to actually swap out all of those appointments and then they have to stand for election. So it just doesn't seem like it's going to be an issue. I feel like Democrats will clearly try and use it as another political wedge issue to be like, see, this is what Republicans are doing. But when you actually break it down, even if Republicans like myself that are very, very pro-life, and I wish I could wave a magic wand and defund all abortions in the state 100%. I don't have the ability to do that, even if I was the governor. In one term, it's impossible to do. Does that sound more accurate?
It's absolutely right, AK. I mean, the current Minnesota Supreme Court is entirely made up of DFL appointees, and that's because you've had 2 terms of Mark Dayton and now almost 2 terms of Tim Walz. So that's 16 years of Democrat governors appointing Supreme Court justices. They age out, and they get and the governor appoints a replacement. Occasionally they run for re-election. There's only been one instance that I can remember of a Supreme Court justice winning, getting a seat on the court by election, and that was, of course, Justice Alan Page, who has had like universal name ID throughout the state.
Right.
So it would be. This is not something that, and I'm sure there may be the fodder for elections in this next cycle, but it's kind of enshrined in the Minnesota Constitution. There isn't going to be any movement on this anytime soon.
Right. I think that was what I wanted to clear up with you, just because I had a number of people talk to me about, hey, what does this mean for Doe versus Gomez? And the fact is that like it, love it, or hate it, that was an independent decision made on a state issue by a state Supreme Court. That's the correct understanding there. Getting into just kind of the final one as I see it, and then kind of want to just open it up for you. But then there was another court case allowing parents to opt out of or excuse their class when class material disagrees with religious beliefs. Am I getting that one right too?
Yeah, the Mahmoud v. Taylor, that was the case named down again on Friday. That one came out right after it was announced, just after the injunctions case. This was a group of parents, and it was across various religious backgrounds. You had Muslim, you had Catholic, you had other, others. What they were, there, as I understand, school board at one point had allowed for an opt-out for parents who didn't want their kids to be part of the LGBTQ education materials in school. And as I understand it, the opt-out was removed, and that's what prompted the lawsuit. And Justice Alito wrote this opinion, and on First Amendment freedom of religious expression grounds, said no, parents can be able to opt their kids out of these programs if it doesn't conform to their if it doesn't square with their religious beliefs. So kind of it seems almost like a no-brainer, but it's a win for religious freedom, put it that way.
Yeah. So this was the end of the Supreme Court's term. Am I getting that right, or do you expect more rulings coming in the near future here?
They have at least one more, Max. They have at least one more ruling to come out with today, and then that's it. There was, and I forget which one it is, but there's another one coming. There's at least one more case that they decided, or that they had to decide. They heard, and they haven't issued the opinion on it yet. So I think there's 9:30 today or something is when they announced the last round of this last opinion.
That's interesting. I wanted to touch on again this idea of parents being able to opt out. From some of the content I've seen from the left, and specifically the dissenting opinion of the 3 liberal justices, they're basically making the argument that if for the context of religious purposes, parents can opt out of, let's say, LGBTQ curriculum, that means that parents can opt out of every form of curriculum, therefore invalidating public school curriculum, which is an insane way to look at public curriculum. I actually think that parents should have the ability to have a say in regards to the curriculum that their schools are teaching. But when we are, I think the question is this narrowed to specific instances of religious disagreement of opting out, or is it even more narrow to only specifically LGBTQ? Do you have any kind of opinion on what the actual implication is in regards to this ruling for parents being able to opt out?
That's a good question, AK, and actually, I think it's actually broader because one of the cases that Justice Alito cites is this Yoder case, which was a Supreme Court case originated out of Wisconsin years ago with the Amish community not wanting to have their kids go to high school because under their faith they were they were basically adults after completion of 8th grade, and they wanted them to be a part of the the community, and the Supreme Court held for the Amish. So him citing that was interesting. I think what he was saying is, if you have an instance that is clashing with someone's religious faith, the faith is going to win out.
Yeah. So the other question that I have is just more of a broader kind of overview of these three cases. And obviously every Supreme Court decision kind of stands on its own, built on all the other previous legal precedent. But it seems like a lot of these are more specifically narrowed to specific situations, but it opens up the door for broader implications. So for instance, in regards to the universal injunctions, they clearly didn't talk really about birthright citizenship, specifically about that argument. And then even more specifically, they didn't outright say that these universal injunctions, so-called, are unconstitutional. The question is, do you think that they will make a broader ruling on a future case? And they're kind of almost like baiting people to say, please bring another case so we can have a broader ruling. And the same in regards to, again, parents being able to opt out. Do you think that there's kind of, again, I guess I would say, kind of flagging to the public, bring us another case so we can make a broader implication? Or is this kind of the reality of most Supreme Court cases, is that they're not always going to be nationwide and wide sweeping?
Well, it depends. Sometimes if they want additional cases to clarify the position, you'll see it in the opinion. You'll see whoever's writing the majority opinion will say, we haven't determined this, right, or we haven't addressed this. Basically telegraphing, bring us this case and we'll address it, right? We don't have that we're not discussing that here. In other instances, they'll issue a ruling that it's intended to be NIPSCO. I think injunctions one is a case in point. It didn't necessarily rule out the IPS of injunctions, but it certainly curtailed the disability doings, right? And this certainly sounds like that this was one of those. How do you get enough votes to go a certain way? And you kind of have this block now. You have the three. I call them the dissent. Sotomayor, Jackson, Kagan are always be on the losing side now. Yeah,
of course. Yeah. As long as Roberts and Amy Coney Barrett don't do any weird squirrely stuff, which they've done a few times.
They're kind of more of the middle of the road. You have Roberts, Coney Barrett, and Kavanaugh.
Yeah.
And have Gorsuch, Alito, and Thomas, more of the conservative wing. Mm-hmm. And it's a matter of getting a combination of those justices together to be able to put together a majority opinion.
Well, Jeff, thank you so much for joining us and giving your insight here. We're kind of losing you on the cell phone, so we'll talk soon. But appreciate you calling in and giving us some insight on the cases that have happened this weekend.
Sounds good. Thanks, guys.
Take her easy.